Hello, you're watching Addleshaw Goddard's Employment Channel on the 25th of November. In today's programme, we provide a brief update on a recent decision in the European courts regarding carrying over holidays during periods of long-term sick leave. We also have comment from Zoe Thompson, an employment law barrister at 9 St John Street Chambers, on a recent decision, again on the hot topic of holidays and holiday pay during sick leave. And finally, Zoe also comments on some of the current trends and issues in the tribunal following the recent tribunal user group meetings. Hot off the press this week, the European Court of Justice has handed down a decision in the German case of Schult about whether the UK working time regulations can limit the period for which employees absent on sick leave can carry over holiday. We originally reported on this case in our news programme on the 14th of July. As anticipated, the ECJ has followed the Advocate General's opinion and has held that there can be a long stop date on holiday carried over, but only where the leave can no longer be described as a rest period. And in this case, a carryover period of 15 months was held to be acceptable and reasonable. So the employee had 12 months, the current holiday year, plus 15 months, the carryover period, to take the holiday. This is good news for employers. It represents a fair balance between preserving the right of individuals to take their leave, whilst recognising the management and financial impact for businesses if an employee is entitled to accrue unlimited leave. We will have to wait and see how the UK courts interpret this decision, but hopefully it will be reflected in the changes to the working time regulations expected next year, following the government's consultation on modern workplaces. On the hot topic of holidays and sick leave, another interesting development this week. This decision in Fraser and South West London St George's Mental Health Trust clarifies the much debated issue of whether workers on sick leave are entitled to statutory holiday pay under the working time regulation. Zoe Thompson, a barrister at 9 St John Street Chambers, comments on this case in more detail and what it means for employers.
The Employment Appeal Tribunal in the Fraser case has held that workers on long-term sick are only entitled to statutory holiday pay if they take or give notice that they wish to take such holiday. Now, this conflicts with another fairly recent EAT decision in Canada Life, which held that workers should receive payments on termination in respect of previous year's relinquished statutory holiday entitlement. Now, the fact that the president of the EAT, Lord Justice Underhill, in this case stated that Canada Life was wrong is likely to hold sway. He said that it would be contrary to the purpose of the working time regulations if workers could receive statutory holiday pay regardless of whether they take time off, as this would create a financial incentive for them not to exercise their holiday rights. So the current position seems to be that workers who work throughout a leave year and forgo that year's statutory holiday entitlement are unlikely to receive a payment in respect of that entitlement when their employment terminates. It follows that if a sick worker wishes to defer taking their statutory holiday to another leave year, they must make a request to their employer. In this case, the worker failed to make any such request, and so her untaken statutory holiday entitlement disappeared at the end of each leave year, and she was not entitled to payment in respect of it when she was dismissed. So all in all, good news for employers, as following this case, they are under no obligation to pay their sick employees holiday pay if the holiday pay has not been specifically requested.
Thanks, Zoe. And finally, you may be aware that regional employment tribunals tend to hold meetings with their users a couple of times a year. The latest round of meetings have recently taken place, and Zoe looks at some of the common issues that have been raised that are likely to impact on employers going forward, including the new tribunal practice of listing unfair dismissal claims for 1 day within 16 weeks of issue. Also, the increase in the unfair dismissal qualifying period and the proposals on the introduction of tribunal fees. Thanks, Zoe. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.